Thanks very much. I hope to shine a spotlight on two fairly concise legal points that have concerned me, and to do so fairly quickly. The reason I got to be here was because I was asked a question towards the end of last week about whether one could use freedom of information to try to find out the legal structures that were being put in place in Doncaster. And although company law isn't the main thing that I do by any means, it's social work law, I thought we don't need to go that way. Company law means I should be able to get hold of those documents and look at them. So I did, and what I looked at shocked me, and what shocked me I blogged about, and that was the circle of events that led to me being here, because what I discovered was 4 days before the launch event for Doncaster on the 1st of October, a new set of Articles of Association was filed with Companies House. And it was the contents of the new set and the fact that it was possible to do it that easily that I want to comment on quickly. So far as the contents were concerned, they gave power to an individual called a designated member, who is the chair who was appointed by Michael Gove to run Doncaster Children's Services. Now, in a company, you would expect some separation, and in this case, it's a company limited by guarantee. That means it's not a private company. So you would expect to have members who can hold the directors to account. What it actually says is that this designated member must approve any other membership application and can veto any member. The designated member can veto any director application. Any existing member or director can be removed by the designated member. The minimum number of directors is 1. The minimum number of members is 1. And the members will choose the next designated member. And why that shocked me enough to blog about it, and that's how I got to be here. It says a lot, it felt to me, and I got into a tweet debate as well about local accountability, because it was being suggested that one of the reasons that we have a problem in Birmingham is that within a local authority there is poor accountability. All I will say is, and I put out this challenge, if accountability were part of the problem, this cannot possibly be the solution. And I also want to observe, as I said, that people have said, well, can you just do this? Yes, it's happened. What this instance shows is how easy it is for private companies, and especially in this instance a private company that doesn't have shareholders, it doesn't have regulation by the Charity Commission, it's not going to be held to account by its members, it's not a community interest company that's going to have any oversight as to whether it has community interest benefit. It is easy to muck about with the constitution of private companies, and they have shown it 4 days before the launch. That's the first thing I wanted to put the spotlight on. Now the other one was a point about human rights, because Birmingham has some form in privatising out of human rights. And it happened a few years ago when Birmingham City Council privatised residential care to a company that you will have heard of, Southern Cross, and a resident who Southern Cross wished to evict wished to rely upon her human rights to oppose this. And what happened was that a dispute went all the way to the highest court in the country as to whether, by privatising out the service, Birmingham City Council had effectively privatised away this 83-year-old woman's human rights. And in the House of Lords, as it then was, the answer that was given was, yes, they have privatised away her human rights. It was given on a majority of 3 commercial judges who said, yes, they have privatised it away, while 2 public law judges said, no, they haven't. In fairness, the government at the time, which was the former Labour government, said we never intended this, and we want to give back human rights to the people who have lost them as a result of this judgment. As I pointed out on a number of occasions, they did it far too narrowly, because I said, why don't you just say that you can't privatise away people's human rights? What they actually said was, residential care residents can have their human rights back, which of course left a gaping hole if Birmingham City Council, let's say hypothetically, were to privatise some area other than residential care. They haven't given them back. And it remains to be seen what a court today would decide as to the human rights status of our service users. And I fear that it could safely be said that if a court today went the same way as the last time that the highest court had to decide the effect of one of Birmingham City Council's privatisation ventures, I don't think I can see the government stepping in to say, let's restore human rights to these service users. So that was the other point that I wished to highlight. And I think I'm in time. Thank you.
Thank you very much.